Hi, good morning, everyone. We're just waiting for a minute or two just to give everyone else a chance to join. So please bear with us and we'll start the webinar shortly. Okay, so welcome everyone. My name is Ryan Cox. I'm the General Manager of Major Accounts for InfoTrack here in the UK. Today we will be joined by our expert, Stephen Sykes, environmental lawyer and consultant from Practical Law. Stephen, I'll hand over to you to run through your agenda for today's 45-minute webinar and let you get on with it.
Yeah, thanks, Ryan. So I'm Stephen Sykes. I'm a solicitor, consultant in the commercial real estate department at Capital Law, where I basically de-risk property transactions from issues like contaminated land and flooding, but now climate too, actually. So I'll be taking you through this new area of risk for our profession. Formerly, I was the chair of the UK Environmental Law Association. And about 50 million years ago, I was a trainee and worked in private practice with Adelshaw Goddards, then went into the city with Allianz, ensuring environmental risks. The main takeaways I want you to have from this are, first and foremost, an understanding of the scale that climate impacts will have on UK real estate. I have some numbers for you. Don't be too alarmed, but they are quite stark. This is not a minor issue. This dwarfs contaminated land and it enhances flooding. So it's a risk we all need to take quite seriously. I want you to also take away a good understanding of the duties that we have as commercial real estate lawyers to advise clients on climate risk, and an understanding where those duties come from. Central to that is was Queen's Counsel, now King's Counsel, opinion that I commissioned for Groundsure as a legal advisor to Groundsure from Stephen Trumans, KC, on what our duties are, and that's available for download on Groundshure's website. But there's a lot of work prior to that being done by the Law Society, which I'll take you through, and other leading legal commentators, including Professor Sarah Degate, former General Counsel at Slaughters, who's done a deep dive on this as well. And thirdly, it's really about the practical steps you need to take as real estate lawyers to discharge the duty. I'm calling it duty of care. There's actually two distinct duties here. One is a duty to disclose material information to clients that we encounter in the course of transactions, duty to disclose. And the other one is a duty to warn our clients, which is a tortious duty, which I'll take you through. Next slide, please. Okay, so some numbers, as promised. Climate change can sometimes seem a little overwhelming, and to some extent it's such a concern that we almost close our eyes with it and don't want to engage with it, which is a bit of a mistake, really, because it is happening. And without panicking, we need to get a sense of what the scale is, particularly for the UK, but potentially further afield as well. And the scale is quite significant. Essentially, what the climate why the climate is changing is the emission of greenhouse gases, and the effect of that change in the UK is, as someone once said, it's wet conditions, particularly during the winter, or extreme climate events that will happen from time to time, and drier conditions in the summer, which we know all about from the summer we've just had. So if you get wetter conditions, you get more flooding. If you get drier conditions, certainly in parts of the UK where properties are built on clay, you get a lot more subsidence. And the extreme weather events add to that and can have all manner of impacts. This is just a snapshot of the biggest ones. You can see on the top there, coastal erosion. the number of properties in the UK at risk from coastal erosion, these are resi figures, I should add, but I know I'm talking to a commercial audience, just to give you a sense of it, a fourfold increase in the number of properties at risk from coastal erosion over the next 30 years. Let's think about that. If that was to affect a commercial property and lead to a total loss of the property, clearly that is a significant concern. Won't happen in all cases, clearly, but we see a significant increase in those numbers. Subsidence is a far bigger concern generally and encountered much more frequently, but equally you see there a fourfold increase over a 30-year time frame. And so it goes on with river flooding, surface water flooding, and coastal flooding. These aren't minor matters. These are taking existing geo-environmental risks, add a warmer climate or a wetter climate, and those risks increase in frequency to such an extent that we are all going to be transacting over the coming decades climate impacted properties with greater regularity, certainly, than has been the case in the past. Next slide, please. Right, so this slide was presented at a climate change conference that I helped to organise at the Law Society in June. It was presented by the Met Office, their advisor, who basically briefs the Cabinet Office on climate risks. And it was essentially a weather forecast designed for the year 2050. Remarkably, and it was, this is what we're heading to, as a heat dome over the UK. Look at all the dark red. Look at what's happening to the country, and we see temperatures there breaching 40 degrees centigrade. That's about 105 Fahrenheit to 110 Fahrenheit. And there was a sort of gasp in the room. That was an event organised for lawyers with a whole series of climate professionals, including Roger Harrabin from the BBC, and senior speakers from the BGS and from the Met Office. So this was projecting forward, and I think everybody thought, well, that's a concern, because we know generally climate change is leading to well, currently at 1.1, but 1.5, maybe 1.7, maybe even higher increase in average global temperatures. But that doesn't mean that we take, say, an average summer temperature of 32 degrees and it will grow to 33.5 degrees. It doesn't work like that. It means there are spikes in weather where the temperature could increase by several degrees in one leap, if you like. Well, just within about 2 weeks of running that event, and it was no perspicacity on our behalf, sure enough, the UK experienced 40 degrees centigrade temperatures for the first time for a number of days. So, without being too scaremongering about it, this is the future that we're heading into. It's been modelled by the Met Office. Some of the geophysical impacts have been modelled by the likes of the BGS and ambiental specialist organisations, and that data's been taken by the likes of Groundsure to analyse and come up with the numbers on the slide that I just gave you. But this is the world that we are heading into. What we don't know is exactly how much warming we're going to get. The aim really is to keep it below 1.5 degrees, so it's not drastically disruptive to the planet. But there are no guarantees. There are scenarios where we won't hit that because of the amount of greenhouse gas that's still being emitted, and it could be much more serious. So, when we get those sort of temperatures, what are the impacts that we need to be mindful of as real estate lawyers? Next slide, please. Well, this was an interesting snippet of information that I came across a few days ago. Those warmer temperatures have particular impacts in parts of the UK where buildings, residential and commercial, are built on clay because the hot weather causes the clay to shrink, and it can give rise to subsidence and property damage. And already from the summer that we've just had, which I think together with summers over the past 15 years, we've had 10 of the warmest summers on record since 2000. The loss adjuster Sedgwick is translating this into subsidence claims. for their insurance clients, and it looks like we're looking at a 300 to 400% spike in the number of properties that are going to suffer from subsidence, which is sort of fixable, but at a price. And there you have a quote from the technical director, a scientist at Sedgwick, about climate change not being something that we can ignore. And that really is the principal point, I think, of this training session, which is it's happening. Let's understand it calmly. Let's figure out what our role is as lawyers and what we should be telling, what we're obliged to tell our clients, and the steps that we can take to discharge our duty of care, protect ourselves from potential negligence actions, but probably first and foremost to provide a good service to the clients so they can make an informed decision. So these physical risks from climate change, yes, subsidence, the flooding impacts we've seen, coastal erosion, the impacts are quite wide ranging. I was asked recently to review the contaminated land warning card, the practice note, to see to what extent that's affected by a warming climate. And the impacts are a little marginal, but if you have extreme weather events, flash flooding and the like, that can mobilize contamination in a way that we've not really encountered in the past. And it's something to be mindful of. And equally, warmer temperatures leads to warmer groundwater. Sometimes there is contamination in groundwater which is staying stable because it's well understood by the hydrogeologist. Add 1.5, 1.7 degrees of heat in there, it changes the flow of groundwater. And it could mean contamination that was okay in one area, plume, say, of bromide, north of London, there's a well-known 20-kilometre plume there, could change direction. So where would it go? If it heads towards drinking water supplies, that is a problem. Now, I guess as lawyers, we're used to looking at worst case scenarios with climate change impacts. What might they be? Worst case scenarios could be a client that buys a development plot to expand their business, and they find that when you factor in wet conditions and dry conditions, particularly around coastal erosion and increased flooding, that it's difficult to get insurance. It might be impossible to get insurance. It might be difficult to get planning consent. Some of the work I do with Capital in South Wales, there's a technical advice note there on planning and climate risk, and it talks about managed retreat. That's the policy of the Welsh Assembly government, the NRW, National Resources Wales, will be following. And there are certainly areas of South Wales on the coastline that are going to be difficult to develop. That's the practical repercussions. That's the world that we are in. Other worst case scenarios could be the loss of property to coastal erosion, or indeed risk to life. Next slide, please. Next slide, please. Okay, so what climate lawyers sometimes talk about are physical risks and transition risks. We've looked at some of the physical risks. There are others: wildfire risks, risks to potable water supplies, quite wide ranging, but they're the principal ones, the ones I just mentioned. They're of the greatest concern to lenders. Subsidence and flooding they're the ones. You can look at the numbers from the earlier slide. That's where, if you like, the rubber hits the road. But there are other risks which are transitional in nature as we move from a carbon economy to a decarbonised economy powered by renewables. What changes would affect businesses across the UK? Where do those changes come from? And they can come in part from changes in regulation, changes in market practices. A transition risk will be a site that's insurable today but won't be in the future because of climate change. That's a transition risk. A transition risk is a site that is suitable for raising debt finance. A transition risk is one where no, it isn't in the future because of these impacts and lenders being unwilling to lend. And lenders are very much alive to this risk, driven by the Bank of England back in 2018 and actually earlier through this year, conducting stress tests on the balance sheets of the largest banks and this is what's happening, the largest insurance companies in the UK, to figure out what financial impact climate risk will have. And they came up with a number of about 525 billion of potential liability if banks don't take appropriate steps to mitigate their risk. So transition risk can also come from purchasers. As we go into the future, will be much more alive to climate change impacts on their land and buildings, partly because of the data that's now available, the analysis that's now available from climate search reports, and what that will ultimately lead to could be reduced market values in time. Next slide, please. So the duty of care, just to step back from this, in October of 2021, just before the Conference of the Parties, COP26, it feels like ancient history, up in Glasgow, the Law Society issued a climate change resolution. I did a show of hands test at a talk I gave recently to see how many lawyers were aware of that. The number was quite low. That's not a criticism, it's just an observation. But by all means, one of the things you should do following this talk is check out the climate change resolution and what the Law Society generally is doing about climate change through its climate change working group that's very active on this topic. This is a little bit of a promotional for them. I think it's well worth seeing what they're doing. Well, in the climate change resolution, it mentioned that guidance is coming our way. I can talk more about that in the Q&A session potentially, but sort of in anticipation of that, in June, and on behalf of Groundsure, I instructed Stephen Trumans, who was a QC then, now a KC, and he provided the opinion in the matter of conveyancer's duty of care to advise clients about climate risk and how to discharge such duty. The genuine thinking then was to actually provide, if you like, a service for the profession by shining a light on whether there is a duty, and to go into that open-minded as to whether there was or wasn't, and if there was, what is that duty, what are we obliged to do, and how do we go about it. And in approaching Stephen Trumans, he really is the expert's expert, former head of environmental law at Simmons & Simmons, former head of Chambers at 39 Essex, incredibly well regarded. And Stephen provided his advice, which is available. Follow that link if you wish to download. I did a one-page summary of it, which Stephen signed off on. What he's saying, as a sort of slight caveat, is that he's not endorsing any particular climate search product, and his advice is provided to Groundsure, not to other parties who may wish to read it and or rely upon it. So he doesn't owe, Stephen doesn't owe any of those of you on the call a duty of care, but that advice is very high level. It sits alongside advice which actually predated it from Sarah Degate, that we'll talk about later. But his main observations, as we'll see, is that there is a duty of care to clients. It's a duty to warn and give advice about risks which conveyancers should be aware of. And Stephen's opinion is that, given the prominence of climate, some of those numbers we talked about earlier, this is not such a minor issue that can be, if you like, swept under the carpet. It's very, very significant. So we should be giving advice to clients about risks that could adversely affect the property in the short term, potentially in the longer term, and could impact the value of that property. And it's all part of our general duty to exercise reasonable skill and care. All the case law to back that evaluation up included in Stephen's opinion. Primarily, it's not specific case law on climate risk, but it's taking the principles from medical cases and other cases, and some Commonwealth cases are also cited in it. But that's really at the heart of Stephen's advice. As I say, it fits in with what the Law Society is doing, because it's producing practice notes on climate change, which we can talk about later, and the advice from the Slaughter and May General Counsel, Sarah Degate. Next slide, please. So what Stephen says, and the instruction I gave him, which is also available for download, the brief, asked him to look particularly at these physical risks, the coastal erosion, the flooding, the subsidence risks. And these risks ultimately, they take some existing geo-environmental risks. I mean, flooding already is a risk, but instead of there being sort of 5.2 million properties at risk at the moment, it's going to grow to 6 million because of residential properties that is, by 2050. So these are property real estate based risks, geo-environmental risks that impact land and buildings. And he states that these are the kind of risks that the conveyancer should be aware of. And then as part of the retainer, take steps to respond to. We'll come on to the retainer shortly, because some law firms might be minded to carve out giving advice on climate risk from the retainers, which for reasons I'll explain is not a good idea. So that's the role that Stephen sees that they should play. Next slide, please. Now, one important aspect to the duty is the nature of the client. And I should say that the precise impact of the duty of care is, as with any duty of care, it's fact dependent. It's hard to completely generalise. But there are a number of facts that weigh in the balance here. And one is the nature and sophistication of the client. If we look at two ends of the spectrum here, if we were acting for a FTSE 100 property client that's got a climate resource team, the duty still applies. It's Stephen Trumans' view, but we don't have to do too much to discharge it, because there's a level of knowledge and sophistication and understanding within that client. They're at one end of the spectrum. If we're acting for a commercial property developer who's on one of their first projects, and this is all new and fresh to them, then absolutely they'll be relying more heavily on us. They are, inverted commas, less sophisticated and have less of an understanding of this, and are looking to us as real estate lawyers to advise. But across the piece, the duty applies. It's just a question of the standard of care that we have to meet to discharge it will vary based on who we're acting for. So it's something for us to take away. If client has a short-term time frame, they're flipping a site, it's not a long-term thing, that's a different position in my view to say a pension fund is acquiring the site for the long term, where climate is definitely front and centre and on the table and will need to be advised upon. Next slide, please. So there's a little bit more to say about this later, but with the duty of what I'm calling the duty of care, the duty to warn, the duty to advise, I asked Stephen to pinpoint in general terms what steps we should be taking to discharge this duty. And he has no doubt the duty exists, and that's the same view that Sarah Degate takes. And as I say, the Law Society is producing 2 practice notes on the very same issue. So it is coming our way. We can't close our eyes and pretend that it isn't. Stephen said in his opinion that a very important development that underpins the existence of this duty of care is a climate search that Groundsure has developed. Groundsure wasn't the first to the market. There was a company called Terra Firma that produced a climate product in April, and at some juncture, the other key data provider, Argyle, which I co-founded and used to chair, they might be producing something at some juncture. Hard to say. I don't have insight into that, but potentially all key environmental providers either have or will have climate search tools, and they are site specific. So they basically will look at a particular property, commercial property that you're transacting on, take the red line boundary and give a rating for the extent to which that property is at climate risk from some of the physical impacts that we've talked about. So that really has moved the debate along, because in the absence of a tool as useful as that, the solicitors could only ever talk in generalities and say to a client, well, you may have a property, you may be buying a property, maybe wishing to develop a property, maybe trying to sell a property that could be exposed to climate impacts. But how helpful is that? Not very much. Factor in these site-specific tools, which provide information and analysis, and the client can then take a view. So it's also a reasonable step for us to take as lawyers to be looking at these reports. In the case of Groundsure, I know the data is provided at no extra cost as part of their existing report. So there's a practical step, and if we don't take a practical, reasonable step, in effect, where there's a duty, it's prima facie negligence. So what Stephen's saying is become familiar with the search services that are out there and take a view as to what suits you and whether you're engaging in this or not. And if you do engage and commission these reports and use this data, what is absolutely clear from the case law, including the bird case at the at first instance, is it's not sufficient for any lawyer to take an environment, never mind a climate search, to take environmental data and simply to forward it on to the client. You have to explain what it means, and you have to put the risk in context, and you have to do so in your report on title, the certificate on title. That's the place to do it. You need, really important to have it written down. Okay, so next slide. Right, I'm looking at the clock, 20 minutes. I might take this at a bit of a canter. That's, I don't know if these slides will be available, but that's a snapshot of the sort of tool that Groundsure developed in the bottom right there, ClimateIndex. You look at a time frame of 1 year, 5 year, and 30 years. Those are the time frames that the Bank of England uses when it conducts the stress tests for the key lenders and the key insurers. So thinking of Groundsure is to make it consistent with that. And you see over time a property that's relatively low risk but transitioning to higher risk over 30 years. We'll come on to what you should do about that, but that's the sort of visual that we're used to as real estate lawyers, where we almost see like a traffic light system and can see that, yes, we've got a new risk here. It's the future risk that's coming down at us in a, say, 1, 5, 30-year time frame. It's a question then of taking some of that information and putting it in our certificate of title, where appropriate, advising next steps. I should say, on the stats that I've seen, it's certainly fewer than 1 in 10, probably around about 1 in 20 properties are being flagged as potentially at climate risk from the data that I've seen. So let's put this in context. 19 out of 20, no. 1 out of 20, quite possibly. Next slide, please. Not to say too much about this, but those are, you see the overall rating for the key physical impacts: surface water flooding, river flooding, different types of flooding, coastal flooding, and you see the changes that are potentially taking place over time. The reason for the ranking of D is coastal erosion, assuming that there's no defence applied. This is a property that's close to the coast. You could be looking at a total loss of the property, and that's why it's rated where it is. I should say there's a lot of analysis that goes into these reports. Groundsure have been doing it for 20 years. I co-founded Argyle in 2004, so that's not far off 20 years. And they're scientists, they're data scientists. They use the data, they draw on the Met Office, BGS, Ambiental, in the case of Groundsure, and the numbers are the numbers. Okay, so next, please. A little bit more about that product. You can see the sort of time horizons that are there, and you can see the various projections that are made and explanations underpinning this. What you're not seeing yet is the next steps, but I'll come on to that for you in a moment. So that's just to give you familiarity with what this data is now looking like. Okay, so next slide, what to do with it. I flagged earlier that the thing not to do is to sort of sit on it. The thing not to do also is not to engage in this and not to have your PSLs figuring out which climate search provider to go with. To do nothing is not really an option. So the advice, this comes from this is my understanding of the bird case from a few years ago, where that was on the planning search, but I think the same principles apply. I know Stephen Trumans is at the same view. What we should be doing to ensure that we're not negligent in the report on title is to summarise the purpose of the climate risk analysis, which is to give this medium to long-term view of physical risk exposures and some transition risks. And I should say, over time, I think the climate risk information is likely to evolve. I don't think the reports that are being designed right now will stay the same for years in and years out. More data will be available, and I think particularly around transition risks, I think they'll be picked up and become more prominent over time. So to explain the purpose of it, there'll be some standard wording that can be developed, and the environmental search providers will no doubt help you with that, to summarise what the purpose of this analysis is, and then to say what the results and the findings are, which in simple terms or traffic light terms is it flagging a problem or isn't it? If it is, then what do you do? And Stephen's Trumans advice is pretty clear on that. Request for instructions. There are some cases where it's necessary to signpost other professionals, including valuers, to give a steer as to what impact climate risk will have on the value of the property. Ultimately, there are cases where the client will just have to take a commercial view, but there are other solutions which we'll touch on. So you've got to sort of engage with the climate search information rather than simple pass through. You've got to engage and think through what to do about it. For those of you that've got environmental law teams, I'm sure they'll be very well placed to assist with that service. Like I say, 19 times out of 20, there won't be too much to say because the risk won't change. But in those cases where it does, perhaps a reference to your in-house environmental team where you have one might be beneficial. Next slide, please. So this is also a summary of Stephen Trumans' advice, where initially I'd advise is outside your expertise, what do you do? There's a sequential step that you can take, modelled on the practice notes for flooding and contaminated land. It's the same kind of thinking, essentially, where in the first instance, the surveyor. This is not solely the surveyor's responsibility. It's a duty of care on us as solicitors, so we can't just shrug it off and say, talk to the surveyor and get a value. No, it comes to us, we analyse it where it's flagging a potential problem. We go to the surveyor and we ask, what impact will this have on value? When you look at the Red Book and the appendices to the Red Book, climate is down there as a factor impacting value through sustainability over the longer term. So it's a question of getting the surveyor then to engage and give a steer or not. It may be appropriate to talk to an insurance broker to say, you know, if this is a trajectory that the property is heading towards, for them to give an opinion as to whether they think the site will be insurable in the long term. If it was in the condition that the conditions predicted to be in 2050, if that was happening now in 2022, would it be insurable? That's the question, and see what the insurer says. Because if you do end up with a stranded asset that's not insurable, that will impact value, usability, and so forth. And you don't want your clients to be having those kind of sites. There may be instances where you go to a flood risk specialist, if it's say a flood issue or a subsidence issue, and say, okay, if these impacts occur, what's the cost to make the property more resilient? And you have a number there, potentially a price chip. That's the kind of thinking to go through the sites that are problematic, that, if you like, fail the climate test. Next slide, please. So risks for us, there's a PI risk, there's a negligence risk here if we duck this issue. If we don't duck it, but we don't record our advice in writing, that's absolutely critical that we do that. We do it in the report on title. But if we were to ignore this, what are the repercussions? Negligence claims, already insurance premiums for the real estate legal profession are pretty high. But if we take losses because of negligent climate risk advice, then potentially we'll be looking at higher premiums and so on. And all the other aspects that we don't particularly want to incur. A few words about ESG and credentials on ESG. I'm mindful that a lot of the larger commercial law firms are either developing ESG capabilities or sustainability capabilities, because that's a whole new area of complex interrelated risks on environment, social and governance grounds. And if a law firm was to be found negligent for not helping their clients understand climate risks and climate liabilities, that doesn't sit very squarely, does it, for those law firms seek to hold themselves out as ESG specialists. So there are some repercussions in that area as well, which would be unhelpful. Next slide, please. Okay, so this is a big one. I'm trying to allow some time for questions, but the first reaction from some commercial property lawyers I've spoken to is, okay, we don't want to be advising on this. This is not what we're about. We're not climate specialists. That's basically carved out from the retainer. I specifically asked Stephen Trumans to say, well, does that work? And he's saying, well, it's not a very good idea, Stephen, because you need the client's fully informed consent if you're going to carve out an area of advice from the retainer. And to get that fully informed consent, you've got to go through this process of saying, this is climate change, it's physical risk, it's transition risks, it could lead to subsidence, coastal erosion, flooding, you name it. And we're not advising you on this. And then they'll ask you why. And you may say, well, we don't feel we've got the expertise, etc., etc. But all that time is building up, and probably it's not chargeable, where you try and if you like, leave the client with a challenge. But even beyond that, in some communications I've had with Professor Sarah Degate, she said that the attempt to limit or exclude the duty is a case called the Hayhurst case from I think 2020, could in itself be a regulatory breach. So it's looking like we've got nowhere to hide on this, and therefore have to engage, not carve it out, and not regard it as something totally inconvenient, but actually as an important emerging area of risk for our clients, which is lawyers. It's our job to help them understand and to mitigate and provide a service for which we charge. That's the way to look at it. Next slide, please. So Sarah Degate, I'll just let you read through that at speed, but you can see the credentials that Sarah's got. She's also advising the government on a few issues, but incredibly well qualified, an M&A lawyer, not a property lawyer. But Sarah first looked at climate duty of care back in March. The Law Society was looking back at this through its climate change resolution in October 2021. Sarah was on it in March 2022, Groundsure, June, July 2022. This has been coming. It may not have been advertised widely, but it's been coming through the Law Societies, these other channels, for some time. So let's see what Sarah specifically has to say. Next slide. Now, anyone who wants it, I can provide a copy of Sarah's article on whether qualified solicitors in England and Wales, not in Scotland, the risk they take if they don't advise their clients on climate. And the opening line there is actually the conclusion to Sarah's 3,500 word article, which is a fairly deep dive into this. And she says, in a definite and resounding way, no, you wouldn't want to risk not advising your clients on these issues. They're so important. What I should say about Sarah's advice, it's not limited to real estate. Spread a word to your corporate pensions, constructions colleagues. This climate duties in Sarah's article are across the firm. It's not just for real estate. And these duties come in two categories. One is the duty in section 6.4, where we've got a duty to disclose material information that we come across, that we actually have actual knowledge of, to pass that on to our clients. So of course, if we're buying an environmental report with embedded climate data, or we come across a climate report on a property, a corporate deal, then we need to disclose that to the client and explain what it means. That's a significant duty, but an even more significant one is the duty to care, a duty to warn, the next one, which is tortious duty, drawn out from the case law, which Sarah analyses, and she's on pretty well on the same page as Stephen Trumans on this. And Sarah's view is it's more extensive because it's not what you actually know, it's what you should know that triggers the duty to warn. What would a reasonably competent solicitor have done? What would they know about these risks in the course of, say, a conveyance or a legal transaction? And it's that objective standard, if you like. It's not what you know, what you should know. And if you fall short, then you're exposed and can be breached. You can breach that duty to warn. So we've got twin-fold duties coming to the fore here. I saw an article in the Times just a few weeks ago, written by, signed by about 170 environmental lawyers and general lawyers, and that talked about duties to the court. So we've got at least two duties. We may have three duties that all come together here, together with the work that Law Society is doing to produce practice notes, which are not legally binding or mandatory, but if we fall short of what the practice note is saying, we may find it more difficult to account for our position if the SRA start asking questions and that in itself could be close to being prima facie negligent. Okay, summary. So what are the takeaways? The takeaway, first and foremost, is that climate change is set to have a fairly dramatic impact on the UK landscape, the real estate landscape, over the coming decades. It's already happening. Look at those subsidence claims and the spike, the 300 to 400 degree percentage spike through the summer that we had, where it was over 40 degrees. So that's already happening. And what the repercussions for that for us as real estate lawyers, there are risks our clients need to understand. The risk we need to understand that we have a duty of care. What's the basis for that duty is an evaluation of common law by, frankly, two of the best legal minds in the country, Stephen Trumans, KC, and Professor Sarah Degate, backed up by the work the Law Society's Climate Change Working Group and Planning and Environmental Law committees are doing to produce guidance in this area. Yes, there's a common law duty to disclose, but the key one is a duty to warn. How do we discharge that duty? We take Stephen Trumans' recommendation and we look at the data that's out there, the site-specific data, and we look at that, commissioning that, or maybe it's already integrated into the reports we're providing, we're commissioning for clients. We evaluate it, and then we then walk through a series of steps that mirror the flooding and contaminated land practice notes to get to a position of comfort for our clients. So, next slide. That was a little bit of a canter at pace, but I think it allows us 4 minutes for questions.
Thank you, Stephen. That was really, really informative. As you say, you've even managed to leave a few minutes for some questions. So if there are any questions that you'd like to ask right away, there's a Q&A feature at the bottom that you'd have all seen. Feel free to put some in there. If you have any questions after the webinar's been completed, then I think, Hafer, if you move on to the final slide, there are some contact details that you can reach out to for us as well. So feel free to take a note, take a screenshot of those details and reach out to us directly. Hopefully you found that all very, very informative. Stephen, thank you very, very much for your time. I know you're busy getting this message out there at the moment. There don't appear to be any questions, so you've explained that extremely well, Stephen. We'll take it as that. And appreciate you getting through within time as well. Thank you, everybody. Thank you again, Stephen. We appreciate your time and we will see you all soon.
Thank you.